There is a personnel doctrine called the Congressional At-Will Standard, enforced through the confidential machinery of the Congressional Accountability Act. No floor vote ever ratified the version now in force, and it has operated since 1995 while leaving no public record of most of the disputes it quietly resolves. By the end of this, you'll understand something most people who work in that building don't say out loud. Here's what it actually is. Every other federal employee in America, every agency worker, every contractor, every civil servant has layers of protection against being fired without cause. Congress does not. A staffer on Capitol Hill serves at the pleasure of one member of Congress, not the institution, not the government, not the public. That member can end that job for almost any reason, and the staffer's only recourse runs through an internal process most Americans have never heard of, the Office of Congressional Workplace Rights. This did not come from a debate anyone watched. In 1995, the new Republican majority passed the Congressional Accountability Act, promising to finally apply workplace laws, safety, discrimination, family leave, to Congress itself. It sounded like accountability. What it actually built was a separate legal universe. Instead of the courts and agencies that police every other employer in the country, Congress created its own enforcement body, its own procedures, and its own timeline. No amendment process ever came back to the floor to revisit how that body actually functions today. It simply calcified into the permanent operating system for every one of the roughly 30,000 people who work for the legislative branch, and almost none of them chose it, voted on it, or were ever asked. Here is where it gets specific. Before a staffer can even file a claim, harassment, discrimination, retaliation for refusing to do something unethical, federal law requires them to go through confidential counseling, then confidential mediation, 30 days minimum for each stage. No public docket, no press access, no named respondent. If the staffer wants to escalate further, they still cannot simply sue like anyone else. They navigate a proceeding structured around preserving the institution's discretion, not the employee's due process. Remember, no one voted for this. Not this version, not this century. Now think about what that means for one person. A committee aide discovers her chief of staff is directing her to backdate travel disclosures. She refuses. 2 weeks later, she's let go, no explanation required, because she was never protected the way a federal employee at the EPA or the IRS would be. She can start the counseling process. She can wait out the mediation window. But there is no whistleblower shield built for her specific situation, the way there is for nearly every other federal worker in Washington, and there is no public record generated that a journalist, a watchdog, or a future employer could ever find. The person who wrote the rule that broke didn't face a courtroom. The person who reported it barely has a paper trail proving she tried. And here's the part that should actually worry you: it's completely legal. Every piece of this was passed, signed, and upheld. There was no scandal, no leaked memo, no illegal backroom deal. Congress simply built the rules for its own workplace, then built the enforcement of those rules to be as private and as internally controlled as legally possible, and called it reform. The reason it cannot be undone is structural, not political. To change it, you need the very body it protects to vote against its own institutional discretion. The same 535 offices currently benefiting from being able to hire and fire without the accountability they impose on everyone else. No outside court can force the change. The judiciary has consistently treated internal congressional personnel matters as the legislature's own business. No agency oversees it, because Congress exempted itself from the agencies that oversee everyone else. It is a lock with the key sealed inside the room it protects. What this should tell you is bigger than staffing. If the branch that writes the accountability laws quietly wrote itself a private exemption from the version everyone else lives under, ask what else looks like reform on paper but functions as protection in practice. Doctrines don't need to hide in shadow to stay invisible. They only need enough procedural fog that no single person can ever prove the pattern. This one has had 30 years to become permanent, And it did that in plain sight, one confidential mediation at a time. So the question worth sitting with is this: how many other institutions have written themselves the same kind of quiet, legal, unrepealable exemption? And how would you even find out if the whole design is that you never see the record?